U.S. Supreme Court is gearing up for a major showdown over medication abortion this week, as the justices prepare to hear arguments in a case that could decide the future of the abortion pill, Mifepristone, nationwide. A coalition of Republican-led states and anti-abortion groups has challenged the Food and Drug Administration's long-standing approval of Mifepristone, alleging the agency exceeded its authority and violated federal law in greenlighting the drug and later expanding access to it. They argue that the FDA's actions, which include allowing Mifepristone to be prescribed via telemedicine and mailed to patients, run afoul of the Comstock Act, an archaic 19th century law banning shipment of abortion-inducing items, and that the medication carries health risks that were not properly accounted for. On the other side, medical experts, the pharmaceutical industry, and reproductive rights advocates strongly reject those claims. They note Mifepristone has been safely used by millions of Americans for over 2 decades. The outcome of this case could be monumental. If the challengers succeed in revoking or restricting Mifepristone's approval, it would effectively curtail abortion access even in many states where abortion remains legal, since over half of U.S. abortions are now medication abortions. The Biden-appointed FDA, now under the Trump administration's reversal, and its supporters warn that stripping away approval would set a dangerous precedent. Ensuring access to FDA-approved medication abortions is essential for women's health, they argue, and blocking the abortion pill would jeopardize you patients' health and safety by forcing those seeking to end early pregnancies into They also contend that allowing courts or states to second-guess the FDA's scientific judgment could undermine the agency's authority to regulate all kinds of drugs. The Supreme Court's hearing, set for Wednesday, will be the first abortion-related battle at the High Court since the seismic overturning of Roe v. Wade in 2022. The legal issues at play range from administrative law. Did the FDA follow proper process? To whether the anti-abortion plaintiffs even have standing to sue over a drug's approval? But the broader context is impossible to ignore. Since Roe was overturned, conservative states have raced to ban or restrict abortion, and now the focus has shifted to abortion pills, a last resort for many in restrictive states. Both sides see high stakes. Anti-abortion advocates call Mifepristone's availability a loophole that undermines state bans. They hope a victory in this case will allow each state or the federal government to ban the drug outright. Abortion rights supporters, meanwhile, have made the abortion pill fight a centerpiece of their post-Roe strategy, emphasizing the pill's safety record and importance for early pregnancy care and miscarriages. Polls suggest a majority of Americans oppose overly harsh restrictions on medication abortion, but the legal battle will be decided by the 9 justices. A ruling is expected by June. In the meantime, the court has left Mifepristone available under existing rules, maintaining the status quo. This case, Missouri v. FDA, formerly known as the Alliance for Hippocratic Medicine suit, could redefine the federal government's role in abortion access and signal how far the court's conservative majority is willing to go in reshaping reproductive rights after Dobbs. All eyes are on the Supreme Court once again, as the future of the abortion pill hangs in the balance. And so it remains